Hey everyone, welcome back to today's video. This time, we're heading to Kansas, where a young sovereign citizen, someone I've covered before, once again finds himself squaring off against a fan-favorite judge, Judge Webster. Now, Judge Webster may look like a kind, grandmotherly figure at first glance, but don't let appearances fool you. She runs a tight courtroom, and she doesn't play around. With that said, let's get into it.
And Judge, I am on standby on Mr. DeBus. Although I'm not attorney of record, I will be standing by though.
All right, and that's what I'm going to call now because it looks like it's between Mr. DeBus and Mr. Cochran. Well, I can't call, Mr. DeBus, you want to start your video? Okay, we are back on the record in 2023 TR 2777, State of Kansas versus Anthony Edward DeBus, with Jared Regier for the state, Mr. DeBus in person, and with standby counsel Darren Patterson. Standby because my prior contacts with Mr. DeBus led me to believe that even though he wants to represent himself, there's much about the legal system that he doesn't know or understand and would need the benefit, or would certainly benefit, period, from Mr. Patterson's representation. So, Mr. DeBus, at this time, you want to talk to Mr. Patterson and take advantage of his knowledge and experience in the legal system concerning this no driver's license charge, registration, and insurance violations?
Let me ask first, are we on the record? Is there a court reporter present?
Is there a court reporter present? This hearing is live. It is being recorded. Is someone sitting here with their little fingers clicking across the keyboard? No.
So you're saying that this is not currently a court of record?
Yes, the proceedings are being recorded, just not by a stenographer. And yes, that means this is absolutely a criminal court of record, no matter how badly someone wishes otherwise.
This is a court of record because this is being recorded, subject to transcription at any time.
Okay. I would ask for a copy of that transcription.
Well, when you file a written motion and pay the transcription fee, sir, that will be arranged.
Okay. And Phyllis K. Webster, will you please recite your oath of office into the court of record then today?
No, sir, I will not.
Why are you refusing to do so?
Let's move along.
I would please like to have that question answered. On another note, I am appearing specially, not generally, under threat of duress and further coercion by the State of Kansas Corporation.
You know, sovereign citizens really need to retire this whole corporation argument. Honestly, if a so-called Walmart Corporation judge ever sent me a summons threatening jail time, I'd tell her to take that summons and shove it straight up the self-checkout receipt slot.
All right, sir. I did take my oath when I was appointed and when I was elected subsequently. Now, what is it I can help you with today? Do you want a trial, a jury trial, or do you want to enter a plea today?
It seemed like last time we had court, you entered the plea for me.
I did, because you would not.
Okay.
But yet what you were saying suggested you wanted a trial, so I entered the not guilty plea and set it for trial. Somewhere along the line, you led me to believe you wanted a jury trial as opposed to a bench trial. Had I been making the decision, I probably would have said bench trial. But somewhere along the line, you've made comments to make me think you wanted a jury trial. Now, I have not seen, let me double check. I don't think, Mr. DeBus, that you have filed any kind of demand or request or notice for jury trial.
I thought that was entered into the court last court session.
Well, I don't think you filed any motion. You told me you apparently you told me you wanted a jury trial, but you never followed through.
I thought that was a decision that we made as the court.
Well, you and I did not make a decision of any kind. Mr. Patterson, do you believe it's acceptable for him to just say he wants a jury trial?
Your Honor, pursuant to case law, because there are at least up to 1 year in the county jail possible, if it's ever consecutive, then case law would state that he has a right to a jury trial.
Agreed, but does he not need to put something in writing to that effect that he wants one? That was my question.
Because there's an absolute right to jury trial, he would not have to put it in writing. It would have to be specifically waived by him, Your Honor, and I don't think he's done a waiver.
Very well. Do you agree with that, Mr. Regier?
Your Honor, what I can say at this time is pursuant to KSA 6238 subsection B, quote, on any issuable trial by right by a jury, a party may demand a jury trial by serving the other parties with a written demand, which may be included in a pleading no later than 14 days after the last pleading directed to the issue is served, and found the demand in accordance with KSA 6205 and amendments thereto.
In spite of that statutory language, do you think he needs to waive his right to jury trial? Did I hear that right?
Absolutely, Judge. Pursuant to case law, and I don't dispute the statute whatsoever, but there is certain case law that makes it a constitutional right to a jury trial if the sentence would be up to a year in the county jail, and in this case, consecutively, it could be up to a year, the longest possible maximum. So it would have to be waived by him, and he would not have to make anything in writing to receive that.
But you don't believe that case law overrules the statutory law, or do you?
This is a constitutional right we're talking about, Your Honor. It would trump the statute.
Okay.
I love how the actual lawyers are calmly discussing the case as if this guy isn't even in the room. Then again, that's not too surprising. When someone has more fingers than IQ points, it's easy to forget they're even there.
So, Mr. Patterson, when you say up to a year in the county jail, are you thinking if they were to be run concurrently, or I mean consecutively versus concurrently?
That would be the longest possible sentence when you start running them consecutively, and that's what the case law would state.
Do you have your statutory site or your case law sites by chance? I know you didn't expect to pull them out.
It's not one I keep handy, but giving a short recess, I can find that.
Well, now, before you go to that, now, Mr. DeBoos, do you have any idea what's going on here?
I, as a common man, do not comprehend the legalese that you guys are using together. I can look up statutes and case law myself, and considering that this is dealing with a common right to all people granted to us in restriction of government entities for the people itself, I comprehend that I have my right to jury trial, which I think Mr. Patterson, in his brief support towards this and towards me, towards my right to a jury trial, although I do not fully comprehend the legalese that is going on within the association between Jared Regier and yourself, Phyllis K. Webster.
Oh, so you don't understand the legal language being exchanged between the attorneys and the judge? Sounds like a pretty solid reason to accept the free lawyer to me. You know, the free lawyer who technically isn't representing you, yet somehow still manages to do a better job than you're doing for yourself.
All right, well, Mr. DeBoos, the point is you do have the right to represent yourself, and you've told me you want to represent yourself, and I've asked Mr. Patterson to stand by, and you've already used him here for this purpose. So here's the thing, Mr. DeBoos. No, let me talk now, Mr. DeBoos. Here's the thing. If you're going to represent yourself, you need to be able to make your own arguments. You need to be able to cite your own law. And if you cannot do that, you have the right to legal assistance, which is why Mr. Patterson is here. And you've already this quickly run into a legal snag that he's made the argument for you. Does it not make sense to you, and do you not want to have his legal assistance to let him represent you?
I do not wish to be represented by a attorney whose duty first is to the courts and not to their clients. And if we're speaking on rights in regards to laws and statutes, the arrest made on me by Deputy K. Barriquet was an unlawful arrest
All right,
for
well, we're not going on
22-2401.
We're not going down that path right now, sir.
Hold on a second, Judge, let him finish. He was citing KSA 22 to 2401, which outlines the legal authority for police officers to make an arrest. Not that the statute has much relevance here, but the irony is hard to miss. On one hand, he quotes Kansas law to argue his arrest was illegal. On the other hand, he claims Kansas statutes are unconstitutional and don't apply to him at all.
Well, the issue is, so you do want a jury trial. Are you ready to proceed on Wednesday, Mr. DeBoos?
May I ask that there be an extension so that way I may fully research the procedures of the administrative criminal law which you're trying to try me under?
Well, I'm not the administrative law judge. That is yet another procedure.
Although you are in an administrative court under the state of Kansas Corporation, correct?
I'm here in a criminal traffic trial, and I am not an administrative law judge. So here's what we're going to do. How much time do you want this continued for?
30 days or so seems to be a standard.
Well, my next available jury trial date would be October 2nd and 3rd. So
2024.
2024. So that's when I will continue this at your request to. I'll grant your continuance, but that's my next available date. And your pretrial will be September 30th, 2024. Do you have any objections to that?
No objections.
And now we have to wait until September to see this clown again. It just goes to show how nonsense like this can completely clog up the judicial system. Before wrapping things up, the judge couldn't resist twisting the knife one last time. She asked the public defender whether there was any legal authority requiring her to recite her oath to the defendant.
Mr. Patterson, do you have any legal authority that suggests that I that I reaffirm my oath for him? Do you have anything that says I should do that?
Judge, I'm afraid I've never researched that issue, never heard that issue.
All right. Well, same here. I do have my oath in front of me. Keep it handy, but I don't see the need to repeat that. It was good enough for the Supreme Court of Kansas.
Alright guys, that's the end of today's video. Looks like we'll be seeing each other again sometime in September, or maybe not. Because, believe it or not, the very next person Judge Webster saw was also a sovereign citizen. That video is coming up next. If you enjoyed this one, hit the like button. If you didn't, hit dislike. Either way, leave a comment below and subscribe with notifications turned on so you don't miss any future content.